Well, good afternoon, everyone. I'm Bill Treanor, the Dean of Georgetown Law, and wanted to welcome you to the afternoon session. And before I turn matters over to the panel, just talk in a few words about why this is a program that really resonates with us, today's conference, and why it's so important to us. Every year we have this conference which brings together experts from government, advocacy, the media, think tanks, and academia to address the most challenging immigration issues facing our country. And this is one of the programs that we're proudest of. Georgetown is committed to this field in many ways. We offer students clinical, practica, seminar, and lecture courses. We offer a certificate in refugees and humanitarian emergencies. We help students connect to our advocacy, practitioner, governmental, and international governmental colleagues in the field through externships, internships, and employment after graduation. So, I'm just very proud of the fact that Georgetown students, as well as our faculty, engage with these issues literally every day. If you haven't been to the campus, when you walk into the library, you see our motto: law is but the means, justice is the end. That's over the door to the library. And that's a motto we take very seriously. With respect to asylum seekers whose current situation will be one of our focuses today, our students and faculty engage every day of each semester in ensuring the proper implementation of the refugee laws by the United States government. In our asylum clinic, teams of 2 students represent women, children, men, and families from around the world in immigration removal proceedings before immigration judges. In recent years, our students have provided excellent legal assistance to asylum seekers from literally around the world. And this year, Georgetown established a volunteer service project for students to provide legal aid to detained families seeking asylum. So over winter break, our first group of 14 volunteers will provide legal assistance to the women and children who are detained in Dilley, Texas. Our students have also conducted human rights missions to research and shed light on the situations of refugees in different parts of the world. On the very first mission of our Human Rights Institute back more than a decade ago, in 2006, our students uncovered the stories of the persecution suffered by many Colombian refugees who had fled to Ecuador. And since then, Georgetown students have focused on issues ranging from access to asylum for unaccompanied migrant children in our hemisphere to the challenges faced by resettled Iraqis in the United States. Following the legal training they receive at Georgetown, our graduates play important roles in the asylum and refugee fields as lawyers in government agencies, non-government organizations, and international organizations. Within the U.S. government, they serve as asylum officers, clerks to immigration judges, lawyers in the Office of Chief Counsel at U.S. Citizenship and Immigration Services, and staff attorneys at the Justice Department's Board of Immigration Appeals. And many represent asylum seekers at non-governmental organizations and on a pro bono basis at law firms. Some are judges in our federal courts who help interpret asylum law. So again, Georgetown Law is committed to this field in myriad ways. So we're delighted to be partnering with the Migration Policy Institute and the Catholic Legal Immigration Network to offer you this excellent program on today's major immigration issues. I'd like to thank Georgetown's partners for organizing this terrific program. I'd like to thank Kara Harris, Georgetown's Assistant Director of Special Events, for taking the lead on all the logistics here at the law school. And of course, and finally, I'm just deeply grateful to Professor Andy Schoenholtz, who has worked closely for many years with our partners at MPI and Clinic. Professor Schoenholtz's research focuses on how the U.S. asylum system works in practice. He also co-directs our asylum clinic and directs the Human Rights Institute, as well as the Certificate in Refugees and Humanitarian Emergencies. So, since I have a captive audience, I just wanted to, just really repeat something that I think you all know, which is, we are deeply committed at Georgetown to justice, and we're deeply committed to the immigration area. And we are just so proud that we've been hosting this conference for 15 years. And, I'm just, it's an honor to look out across the room and to see so many people who are so deeply committed to this area. So let me turn matters over to our panel for the afternoon. Again, thank you all for being here.
Thank you so much, Dean Treanor, and thanks for the hospitality that Georgetown has offered us for the last 15 years. Back to the program, and thank you so much for finishing your lunch on time and making it back to this full audience this afternoon. This is a panel which I don't think we had difficulty finding a title for. We looked at the number of policies that have been implemented in the last 2 years by this administration. There have been so many of them, we couldn't cover all of them, but we thought that we needed to have a panel at least to look at 3 or 4 discrete issues and policy, which may have implications much broader than the initial goals and audiences of the policy. They have ripple effects which are chilling in many communities. And those are the topics we have identified for discussion this afternoon. We will look at basically 4 topics and do as much justice to them in the short period we have. We'll look at this hot button issue of family separation, which we touched on a lot in the panel this morning. We'll look at the contentious policies on sanctuary cities. We'll look at the denaturalization plan that Director Sisna talked briefly about. And finally, the most recent proposed rule on public charge. And to do that for us, we have this really distinguished panel, and I frankly decided to sit in the middle, not at the end, because there are 4 of them, and I couldn't see all of them from the end. But this is really a group of people which has been immersed in various parts of these policy issues for quite some time. You have their bios here, so I won't read them, but let me just quickly give the highlights of who they are. Jonathan Blitzer, to my left, is the staff writer of The New Yorker, but that doesn't do justice to his work. He has become one of the country's most really effective journalists, looking at the anatomy of the policies of ICE and CBP and their implications on the lives of people. His reporting in The New Yorker is extremely compelling, and those of you who haven't seen it, I really urge you to do that. On my left is Commissioner Bitta Mostofi. I'm from New York City, so she's my Commissioner of Immigrant Affairs for Mayor de Blasio's office. Before she became Commissioner, which was only about 6 months ago, she had a very distinguished career as someone who had advocated for refugees and asylum seekers and victims of crime, and for people who have faced discrimination of our immigration policy. So she brings more than her present qualifications to that job. On my right is Jaddou, who actually, talking about the 3-legged stool that a government is the only one here who has occupied 2 of those legs. She was Chief Counsel at the USCIS and had a very important role in the policy making of the department in the Obama administration. Before that, she was also Chief Counsel of the House Subcommittee on Immigration and Border Security and looked at this issue from the congressional perspective. She now teaches at the American University School of Law and is director of the DHS Watch at America's Voice. And our last panelist, we are so glad to have him for the first time at our panel, is Jim Peterson, who's a senior lawyer at the Judicial Watch. And he has been the chief lawyer responsible for various brief submissions that have come from Judicial Watch on various important public policy issues, especially regarding enforcement. He was, I particularly want to note, was the lawyer for the state legislature of Arizona in the 1070 litigation. Welcome to all of you. So we'll do this in this conversational way and probably in 2 or 3 chunks of conversation and not one, and then hopefully we have some time for questions and answers. So Jonathan, let me just start with you, and let's focus for a little while on this hot button issue of family separation. It obviously captured the attention of the country in an unprecedented way, and as Dara laid out for us this morning, also in many ways defined the culture war. that is now ever present in this immigration debate. I know you have looked at a lot about the impact on the lives of these people, and I do want you to talk about that. But could you also, since this is a conference on policy, could you take a step back and tell us from your reporting, what was the administration trying to achieve in this policy? Did they have an agenda here? Was it well defined? And then was it well articulated in terms of the pieces they had to put together for it to be effective? And was that done? And if it wasn't done, was that what led to the big implosion of the policy that we saw in the middle of the year? So why don't we start with that?
Thank you. I mean, those are overwhelming questions. I think, sort of broadly speaking, as a journalist, I'm trying to understand as dispassionately at the outset as I can what the administration has in mind with a policy as obviously extreme as the family separation policy from this summer. And even when I say this summer, that kind of locates the drama to this summer, but obviously the thinking predates that. And I want to talk about that. But I think the family separation policy matters a lot in the context here of our conversation because of the magnitude of the human suffering involved, the administrative failures in its actual implementation, and in the broad public outcry, public political outcry, as more and more information about what this policy looked like came to light, and whether or not that, in fact, had an impact on how the administration continued to pursue this policy. And so, in some ways, I almost need to separate my thinking about this issue into sort of two broad pieces. The first is sort of what the administration said it was doing, how comfortable it increasingly became in embracing that rationale publicly, and what, if anything, it did when evidence started to come back that its plan was going seriously haywire, if in fact they saw it that way, which is another question. And on the other side, I do want to talk about just the unspeakable human suffering that was the result of this policy, because as I spent the summer talking to people and meeting with separated parents in detention, and as they were immediately released from detention, it really, the impression I had, and I realize this is sort of an emotional thing to say at a conference that is a policy conference, but it was just a gratuitous suffering that really made you question the extent to which any of the rationales adopted publicly or privately by the architects of this policy, if any of those rationales were made in good faith. So, for me, in terms of trying to understand where the administration was coming from and beginning to embrace this policy, there are, to me, sort of three broad moments that help me conceptualize what the thinking was. And just in terms of sort of raw motivations, my understanding of what was at stake for the administration here was, to put it broadly and simply, to end catch and release at the border, to tighten the screws on asylum seekers at the border, to do everything within the government's power to try to restrict entry into the United States by those seeking asylum, and to try to deter, and I want to talk a lot about that word, future immigrants who are making that trip for themselves or for their families. That's kind of the idea behind this. But the three moments I want to focus on are these. The first, and none of these will come as a surprise to you, I don't think. I don't often speak to crowds this expert in these subjects, so it's very kind of comforting to know that we share these points of reference, I assume. The first is March 2017. At the time, John Kelly, who's at that particular moment was the Secretary of Homeland Security, publicly broaches the idea of separating families. This, as far as I know, was the first time the administration sort of publicly leaned into that prospect. And the response was immediate and swift and unmistakable, and overwhelmingly in opposition to what the human costs of that policy would be. And interestingly, Kelly retreated for the time being. And I flag this moment because obviously the administration did not continue to retreat from that policy, but it's an interesting inflection point because clearly in March of 2017, the idea of pushback was somehow enough to give the administration pause. So what happened between then and the next moment I want to focus on, and I'm trying to move swiftly, I know I've got 5 minutes. The next moment is August of 2017. Obviously, a lot has happened between March of 2017 and August 2017. But in August of 2017, there was a meeting at DHS led by someone maybe familiar to many of you named Gene Hamilton, who had a senior role at DHS and was formerly an aide to Jeff Sessions, now at the Department of Justice. And that meeting in August of 2017, and I've done some reporting around what was actually said in that meeting. That meeting was essentially kind of preliminary effort to just move forward, to do this, to pursue any policies the administration could to scare people from coming to the U.S. and seek asylum. The family separation issue came up then. It came up then, importantly, alongside other proposals we've since seen being put into effect in some fashion. So, for example, attempts to end the Flores Agreement, related enforcement measures at the border. And there was a real sense from the reporting I've done that among those present, all were taken aback by how aggressive the call was to move forward on this. The reason that matters is because there wasn't much of an interest in actually creating a proper architecture at that time, either behind the rationale of a policy like this or the possible implementation of a policy like this. And so the idea actually didn't quite go forward then either, but it to me represents a kind of a moment of inching toward this sort of comfort with embracing a policy like this. So we've got March 2017, Kelly retreats. August 2017, Kelly's no longer at DHS. And the sense there is, particularly at a time when the Trump effect at the border seems to be ebbing somewhat, there is a sense of, okay, we need to double down. And the last moment before we get into familiar terrain of what this suffering entailed over the course of the summer was early April of 2018. And the sort of sensational and sensationalized news about the Migrant Caravan of mostly Honduran asylum seekers heading north. This obviously exercised the president to an extreme degree. It led him to publicly chastise and mock and belittle his Secretary of Homeland Security, someone who ironically has actually very much embraced the Trumpian mission at DHS. But it, I think, in some ways helped catalyze this sentiment among the architects of the policy that we now know about. It catalyzed that sense of, okay, time to move forward. And in some ways, politically, that was the missing piece, this kind of green light from the White House. And I should say, because this is what it was, histrionics from the White House on this. And so, time is short. In my thinking about this, reporting on it, I'm trying, to the extent that it's useful, and I'd be curious to hear if people think this is in any way meaningful, I'm trying to make distinctions when I look at who's shaping these policies between sort of enforcement hawks in the administration and ideologues. And obviously there's overlap. But I do think in terms of looking at this policy and looking at the ways in which this policy was both more extreme than any of us could have imagined and also much more chaotic than any of us would have expected, it's important to think about these two key groups. The common thread among them, among the enforcement hawks on the one hand, and so I'm thinking, I have in mind Kevin McAleenan at CBP, someone who has not gotten as much scrutiny for his role in all of this, someone like Tom Homan, who at the time was in charge of ICE, and then the ideologues, that is to say people at the White House, Stephen Miller, this person Gene Hamilton, Jeff Sessions. The common thread in their thinking, as I understood it, was deterrence, to try to scare people away. But one thing that's never been clear to me, and that I think we should interrogate in this panel, is kind of what deterrence was supposed to mean. What metrics were there ever to analyze whether or not deterrence was a measurable or concrete phenomenon that could drive policy? And you know, there's information that came out. I mean, this family separation policy, obviously, as you all know, there was a pilot program for this in the summer of 2017, around the same time that meeting was held at DHS, when evidence came back from West Texas that a similar policy adopted in the name of zero tolerance that led to the separation of families at the border did not lead to any meaningful deterrent effects. And so that information is coming in, and it's not giving anyone pause. And so I guess the questions I would raise more generally, as I'm trying hastily to wrap up, are, you know, to what extent is deterrence really just punishment, just inflicting punishment and pain at the border because it's a thing the administration can do, and because that is very central to how it sees itself, kind of policing this broader agenda. And you don't have to take my word for it. I mean, as tendentious as that sounds, punishment is actually the rhetoric eventually that the administration openly used to justify these policies. And you don't have to look much further than who CBP referred for prosecution at the border in, say, May of 2018. They only referred, I don't have the statistics in my head exactly, but my understanding was they referred about a third of all of the people they arrested at the border to DOJ for prosecution, which is to say they made a conscious effort to refer for prosecution parents, knowing full well that would lead to the separation of families. And so the question is, if you're looking at data suggesting that most people at that moment in time who are crossing the border illegally are single adults, why is there this particular focus on family units, if not to try to inflict maximum pain, make that be a sort of centerpiece of the agenda? I'm going to skip over a few other points just in conclusion. I guess the obvious question that this all leads to is, is the administration learning any lessons? Of course, that's a naive formulation because that presupposes an interest in some of the facts on the ground. But I want to just emphasize, in July of this year, as all of this stuff was going on, after the judge in San Diego issued that injunction for the administration to reunite separated families, there were a new set of meetings being held at CBP starting in July that were basically a continuation of the conversation from August of 2017 about how to tighten the screws at the border. And so the conclusion the administration drew was not, we seriously and grossly overstepped. The policy itself failed in all of these very specific administrative ways in which we could discuss. But instead it was, okay, let's double down and be more systematic about this. You had failures, leaving aside the human cost, on all kinds of administrative fronts, essentially the return to catch and release, which only dramatized the fact that this was the policy that the administration was fighting against to begin with. The administration had to essentially concede that it needed to go back to that. In September, last month, there was an extraordinary agreement reached by the Department of Justice in relation to 3 lawsuits that gave 1,000 parents who'd been separated from their kids another chance at pursuing asylum because they'd been coerced into abandoning their immigration claims. This was chaos. This was extraordinarily painful failure. And I want to continue over the course of this panel to interrogate what that's meant and what it will continue to mean.
Great, thank you. Listen, I feel embarrassed myself asking these people to summarize a lot of what they have learned in such a short period of time. So with that, apology in advance.
Sorry,
you could
guys.
talk about any of these things, Bitta, but talk to us first about sanctuary cities. We also know the connection here. A lot of the families that were separated at the border actually found themselves in New York City. So someone like Bitta had to deal with that aspect of the separation of families. So I'll leave you alone on that for a second. But speak to us about sanctuary cities. New York is probably unusual in the debate on sanctuary cities. We forget that it has had a bipartisan reaction to sanctuary cities for a long time. People forget that our Republican Mayor Rudy Giuliani was the first one after 1996 to bring lawsuit against the federal government on the sanctuary city phenomenon on 10th Amendment grounds. So we have had long history on this, but we have never actually had to deal with the intensity that the city has dealt. So you brought a lawsuit again. You sued the federal government. And could you tell us first what made you decide bring the lawsuit, what the basis of the lawsuit is, and then tell us what the effect of the sanctuary city policies is having on the government and on the people.
Thank you. Thank you to MPI, to Clinic, and to Georgetown for hosting us today, and to all of you for being here. So I want to pull back a second and sort of putting my city hat on, which is very different than sort of the way that we've been talking about all of this, which is kind of amorphous and from the top. When you talk about what the responsibility and roles of cities are, it is fundamentally to advance the public safety and health of our residents. And when you talk about how you do that and what that looks like, you're talking about a very complicated question if you start to divide up your population, right? You get certain kinds of protection because you are a citizen. You get certain kinds because you are a legal permanent resident, or you're a dreamer, or you're undocumented. When you talk about a city of New York, 3 million people in the city of New York are foreign-born. 47% of our population. When you add, 37, sorry, when you add in the children of immigrants like myself, that takes you to 60% of the population. We have an estimated 500,000 undocumented individuals in our city alone. People speak upwards of 200 languages. We estimate that there are 1 million people in mixed status households. So you're talking about households with citizens, with legal permanent residents, with somebody in that household who is undocumented, or multiple people. So when you talk about good governance and how you effectively advance the interest of public safety and health as a city policymaker and leader, you have to take into consideration that reality that's on the ground, because otherwise you're completely binding your hands on how you can effectively administer policies. And so therefore you prioritize. And as you just heard from Muz, there's been a decision in New York City, not under Mayor de Blasio, not under Mayor Bloomberg, but as far back as Mayor Giuliani, to fight for the right for municipalities to be able to make decisions about maintaining the trust between the city government and immigrant communities, regardless of their immigration status. And Giuliani even went to court to do that, and they established new confidentiality laws. And the reasons are simple. If I am undocumented and somebody commits a crime against me, and I'm afraid to talk to the police department, and therefore I do not do that, I do not report that crime, my neighbor, who might be a US citizen, is no better off, right? If my child is a US citizen, but I'm afraid to access health resources for my child because it might impact my immigration status or the way that the city receives me, then I might not do that. And that doesn't make my child's schoolmates any better off. And so the way that we really think about policies is how are we fundamentally advancing the safety and health of our residents? And everything that the city does is in compliance with the law. And what you heard Muz talk about a little bit is a very specific moment in time now that we're in, with cities being sort of dubbed sanctuary cities, and therefore that somehow having some connotation that cities are violating law or harboring criminals, when in fact the complete opposite is true. And many of us choose not to use the terminology of a sanctuary city because we actually think that's misleading, because the federal government conducts immigration enforcement in our cities. There's nothing that the city does that limits their ability to be able to conduct their immigration enforcement under the law. What the city says is that we are not an arm of that immigration enforcement, that is not the role of a municipality. And if you make that the role of a municipality, you endanger the rest of our residents. And how this has come to pass most recently is I have a timeline so I don't mess this up, but in January of 2017, the Trump administration, through executive order, essentially began to say that it would look to deny federal funding or grants to so-called sanctuary cities. So this is sort of the first time we see the terminology of sanctuary city appearing in any sort of legal document. How that ends up coming to pass is they specifically look at a grant stream called the Burn JAG program, which is a criminal justice grant that the city is perfectly entitled to, and many cities throughout the country have accessed for many years, including New York City. And just by way of quick history, the Burn JAG grant is named after a New York City police officer, and Eddie Byrne. And it's named after him because he was killed in the line of duty. What was he doing? Well, Eddie was protecting a Guyanese immigrant who had been the witness to criminal activity and had come forward and reported this to the NYPD. And in his line of protecting that individual, he was he was killed. And this grant was named after him as a criminal justice grant. So the very kinds of policies that enabled that individual to come forward and report a crime to NYPD, and that officer following through in his duty to protect that individual witness, is what was essentially being attacked by saying, the federal government saying, because you as a city or cities, they didn't just attack New York City. I have a colleague from Philadelphia here who's on the front lines of this as well. You are not in compliance with a section of federal law 1373. And there's a lot of lawyers here who can speak more on this later, I'm sure. But essentially, which prohibits government agencies and officials from restricting the sharing of citizenship and immigration status information to federal officials. The city of New York, as many cities, said there's nothing about our laws or practices that are in violation of 1373, first off. And second, we question whether or not 1373 in and of itself is something that's constitutional. Putting that aside, DOJ said, in order to qualify for the Burn JAG grants, you not only have to demonstrate compliance with 1373, but we're going to put two new conditions on our grants. One, that with 48 hours notice, you will give us information on somebody in your custody. And two, that you will give us access to your jails. So we were essentially not awarded the grant. We never received a decision. And therefore, the city of New York filed litigation to essentially suing the Department of Justice in saying that we were unlawfully denied our Burn JAG grant. And so that litigation is ongoing. There's other litigation in the country to this effect as well in different cities, including Philadelphia and Chicago. This is, I think, an ongoing battleground in the moment that we're in. But I would sort of urge everybody as they're sort of looking at this to go back to where I started, which is when you're thinking of policies and practice and what the role of cities ought to be, it is fundamentally bad policy to suggest that the role of cities should be to advance immigration enforcement. Cities have chosen, like New York City, to cooperate with enforcement when there is a public safety issue at the heart of it. New York City is a part of joint task forces like terrorism task forces and anti-trafficking task forces and narcotics task forces with immigrations and customs enforcement because that drives the public safety agenda of the city as well. New York City complies with immigration enforcement requests for information or for detainers when we were presented with a warrant by ICE and when that person has been convicted of a serious or violent offense outlined by the city's local laws. But the ability, and this is key, the ability for the city to articulate very clearly that it will not cooperate or advance federal immigration enforcement when it does not advance the public safety and interest of the city must be something that is solely and wholly within the responsibility of the city government to set out and must be taken into consideration when you're looking at how cities can be expected to advance the public health and safety of all their residents in a very complicated, as I noted to begin with, setting and situation when so much of the population is mixed, and this you are or you are not is just an arbitrary delineation of how things actually happen and play out and the impacts on the ground.
Great. Thank you. So just to prove how diverse this set of policy issues are, I'm quickly going to segue into denaturalization. Again, Ur could talk about all these issues, but I just ask her to focus on denaturalization. Sure. Just because it is obviously one of these issues that has recently gotten public attention and has had some chilling effect. Sure. And as you heard Director Assistant this morning, they believe that it is being overblown in terms of what its intent is. But I do happen to know that you were at USCIS when the Obama administration started something called Operation Janus, which is what Director Assistant referred to. So they were basically saying, look, don't blame us for this. We inherited this from the Obama administration, and we're just continuing with it. So tell us, how did it start in the Obama administration? And if this administration is doing it any differently, what is the difference?
Sure. Yeah, and thank you for doing that, because as I was thinking about preparing for today, I thought it would be useful to understand what this is, what the history of this issue is. And it is laid out very clearly in a public September of 2016, Inspector General report from the Department of Homeland Security. And I encourage you all to read it to have a clear understanding of this. But essentially, this is not a new issue. That is really important to understand. This is something that was first discovered in 2008, and efforts began to address it. And essentially, it's a relic of the past at a time when hopefully we have completely solved this problem, where fingerprints were obtained on paper and kept in paper files. And eventually, we have now moved towards a digital, not only collection, but repository. And a lot of fingerprints that were collected on paper were moved over to these digital repositories. And that is where they are kept. And when someone seeks naturalization, those fingerprints are checked against those databases. And the fingerprints from long ago and today are all in there. And so you can check to see people that are submitting the same fingerprints are the same identity or not. It was discovered in 2008 as the comprehensive move towards digital collection and repository was pretty well underway and almost complete. It was discovered that there were several hundreds of thousands, quite a bit, maybe even more than that, were not in the systems. Those paper fingerprint documents were not in the fingerprint repositories. And so when people were seeking naturalization, that identity that they had under a separate set of fingerprints was not caught. And so as they moved these old fingerprints into the systems and then ran them again, they found some cases where people might have had a different identity. Now, as we all know, sometimes there are reasons for it. Sometimes there are not, and sometimes there might be reasons that could be misrepresentation. So the IG identified, the Inspector General identified about 1,800 cases that it suggested that USCIS look into. Now, that was something that was already being identified throughout since 2008. But it was the IG who noted, there could be a little bit more here. You haven't looked at this, you haven't looked at that. There are also, I believe they noted about 148,000 more fingerprints that needed to be uploaded into the system. So there was a series of steps that needed to be taken, and the Inspector General was noting that, and that was September of 2016 after a multi-year effort working on this issue. So nothing new, that was 2 years ago. Certainly, I was there when the IG reported on this, and there were efforts underway to look at those 1,800 cases, look at everything that was noted in the IG, and the IG report notes that certainly DHS had taken a look at the recommendations and agreed with them, and they would begin working on them, or continue their work depending on what it was that was noted. So nothing new, yet all of a sudden there's some announcement in the Associated Press. We have this renewed effort, and it's public. And you wonder, that's what I wonder, why the public effort to go out there, of all places, the Associated Press, and say, there's this, not a task force we heard this morning, but there is an effort underway to ensure that we have lawyers and adjudicators who are looking at this. After it's been around for 10 years, after the IG reported on it 2 years ago, after there have been efforts underway to do all of this, and I certainly saw some of them. So why? What was the reason? And that's what I think is most concerning here. What is the purpose of doing it in this way? And speaking of the title of this panel, Chilling Effects, when you're talking about a few thousand cases, I think this morning the director said 2,500. When you look at that in the grand scheme of things, 700,000 people have naturalized each year, and we're talking over 20 years. That's quite a few people. So when you're looking at 2,500 cases, this is a tiny problem. This is not a huge problem that is deserving of an Associated Press announcement that we have to, harnessing all of our efforts with lawyers and adjudicators. So that was the first thing that caught me. Secondly, I just had a lot of questions, and I continue to have those questions, and I think this is, to me, what seems to be so concerning. This is you try to look up some statistics about the numbers of people that have been denaturalized in the past. I didn't find an official government number, but it appears there are about 300 since 1990, with a large, significant number of them who were war criminals, Nazis or other type of war criminals. And here we're talking about 2,500 cases. So that's a huge increase. And as defined by the IG, these are not war criminals. So, well, we don't know for sure, obviously. Maybe one or two, maybe some of them might be. But what I'm saying is what the IG identified was, in their minds, misrepresentation or fraud to that effect. So when we're talking about such a massive increase, we should have a lot of answers. This is naturalization, and if the government has not made such a dramatic effort in the past, with a large increase like that, number one, and number two, the increase in the types of cases they're looking at. So there need to be some answers. Another point, in the ICE 2019 fiscal year budget request, there are some notes in there about additional leads and additional cases. And it's vague language suggesting that about 700,000 case files need to be looked at by ICE. I don't know what that means. I think that the public deserves answers to understand where is that going. Does that mean there are going to be several thousand more people that could be added to this than the 2,500? There's also a $200 million request for USCIS form fee money, the immigration examinations account money that should be that they are seeking to have transferred from USCIS to ICE for these efforts, among others. I think we need to know what that is. We're taking form fee processing funding money and giving it to ICE for this effort. So another point. I think another important issue is to talk about what is the criteria exactly? What is the full scope of this? We have heard, of course, we heard this morning about the IG report type of cases, but we're also hearing about other types of cases that don't match the description in the IG report. There was a case in the Miami Herald about a woman who had who's been in the country for 30 years and subsequently found herself in denaturalization proceedings. She had assisted the FBI in some kind of fraud scheme, a multi-million-dollar fraud scheme, but it didn't appear that she was one of the heavy hitters. She was just a secretary there who didn't really make money off of this. Anyway, she had assisted the FBI with this, and now she found herself in potentially denaturalized. So that doesn't fit the IG. Is there more outside of USCIS? Is ICE doing something differently? Is DHS as a whole doing something differently? So I think there are a lot of questions like those. And then ultimately, what criteria is being used to determine whether the person will actually be denaturalized or they will seek denaturalization? And will the equities be considered? If a person has been here a long time, the Supreme Court has noted the longer a person has been around, denaturalization may not be the appropriate step. Though I believe, given the unprecedented nature of this effort, the numbers, the types of cases, a lot of the questions we have, there should be some answers before this administration proceeds. Thank you.
Great, thank you. And I guess I suspect for a different flavor, we'll turn to Jim Peterson. Jim, so respond to this from how the Judicial Watch sees these issues. Either collectively, is there a common thread among these things that triggers Judicial Watch's response? And if you share any of that with the administration, how do you share it?
Well, I think there is a common thread, and first, thank you for inviting me. It's kind of good to see a group both this morning and this afternoon that's willing to, entertain different views potentially, or very likely. Obviously, what we do in Washington and across the country today too much, I think, certainly is just talk to each other, talk to people who agree with each other, and not engage with those who might have different views. That leads to the situation I think we're in today, as the panelists, I think, have shown quite well, is where we have situations that result in very difficult, very messy, very unfortunate consequences because over a period of now decades, our immigration laws have not been enforced. Nor have they been changed to adjust to whatever the American people might want. And that leads to these very difficult situations. And instead of, now many of you are saying, well, our Congress won't do anything, so we have to do anything. Well, absolutely. I agree. The Congress is the elected representatives of the people, and they have not fixed this. But the problem is that by not addressing that and not expecting our representatives, demanding our representatives, compromising with others that might disagree, it's led to these difficult situations where we have now large populations that live, frankly, in open defiance of the law. This leads to frustration by many other Americans. It leads to frustration around the world. You can see now in Europe and elsewhere how we've reached the situation where countries' populations see that their laws are not being respected. They see migration that they think is uncontrolled, and because those people there, and frankly a lot of people here, see that their will is not being reflected in what's going on, it leads to people being elected in those countries. It leads to Donald Trump being elected here, if you will, because people have reached a frustration level with all of these problems that leads to situations that now make the system and the situation, frankly, untenable in many ways. Now, our perspective from the organization I've worked with, we've worked on this issue for more than 10 years in different respects. We've tried to do what I thought we could all agree on, and I've always thought we could all agree on, is that the most important value is respect for the rule of law. And certainly, as all the lawyers here should agree, that is something that is frankly at risk as we move farther and farther down this road where we have laws that say one thing, but we do and proceed, often for quite understandable reasons, we do act in a different way. That fundamentally, even beyond this issue, has a corrosive effect, in my view, on the rule of law. This cannot continue. Otherwise, we have these situations where one administration works to punish a state and states and localities that try to advance the goals of federal law. In Arizona, as the Obama administration did, they did everything they could to punish Arizona for doing, frankly, what was the stated goal of federal law. Now, because the administrations have changed, we're in this upside-down situation where the states and localities are holding out, and the administration is trying to punish them for doing the opposite. I mean, we've just reached these situations and then that have terrible effects. We have an administration, we moved from the prior administration that took one view of enforcement of law. Now we have a new administration that trying to, rightly or wrongly, in your view, whatever your view is, it's trying to enforce the law, and it leads to these very, very difficult situations at the border and elsewhere with significant human costs, all as a result in the end, because we haven't respected the fundamental principle of rule of law. If we have the law, enforce it. If we don't like the law, let's change it. But these situations where we try to move around the law, we try to ignore the law, we try to hope it is something else, just leads to more and more of these situations. And and probably the most frustrating and the final point is that what's frustrating for, I think, everybody, both on any side in these debates, is when the unelected bureaucrats, the regulators, step in, maybe out of necessity sometimes, step in and start making policy, further frustrating people that see, on both sides, that see that it's not our elected representatives, but it's the administrative state that is now making policy for us. Of course, we see this in all aspects, in many aspects of the federal government today, because we have apparently a legislative branch that's unable to act in any meaningful way in so many areas, and policy is only being made by the administration of the day. This, in our view, from a broader perspective, is the root cause of all this, and the only way around it is to return to a view where the rule of law is respected. So thank you again for inviting me to this very important panel.
Thank you. So the last thing I want to do at a law school is to ignore the argument about rule of law. But let me just for my own, the assigned task that I had, I have to cover one more topic before we go to that philosophical issue, which is the public charge. So if you don't mind doing it really quickly. So how is the public charge announcement received by New York City as the government and as your representative of the community? And then, Jonathan, if you don't mind, I'll ask you to do the same thing on the basis of your reporting. I'm glad you're going first.
Yeah, I was trying to get you to go first, but that didn't work. Thanks, Mel. So how many are kind of deeply familiar with the 455 pages that were published? Okay, great, a good handful. So I will very, very quickly talk about this. You heard the director this morning touch on it briefly. DHS posted on its website a new regulatory proposal on public charge. It has not yet published that, though we learned this morning that should be any day now, after which there'll be an official 60-day comment period. Get your pens ready. So basically what we know has been proposed, thankfully, is much more narrow than leaked versions and iterations that many of us had been tracking for well over a year now. But what it does is it does greatly expand the current test. So looking at sort of how somebody who is applying for admission or to adjust status in the United States, whether or not they might become a public charge on the government. So the way that test had currently been applied is somebody who's primarily dependent on the government and for their subsistence, right? Very, very narrow definition of cash assistance and long-term rehabilitative care as examples. The new test proposes to be much broader than that. It has a look-back period of about 3 years, specifically naming anybody who's received SNAP, so food stamps, Medicaid with some notable exceptions, Medicare Part D, which is essentially for seniors who receive prescription drugs, Section 8 vouchers, and rental assistance and subsidized housing. They're looking at both the receipt in the past 3 years of any one of those as automatically decision points to show that you are a public charge or that you could be, as well as a very broad sort of totality of the circumstances evaluation, looking, as you heard from the director, at health and age, education levels, income, amongst other things, to assess whether or not in the future, prospectively, you might be a public charge and therefore inadmissible. There are a lot of things about the proposal that are extremely problematic from a city perspective. I talked a lot about the challenges in a population where, as I said, at least 1 million households have somebody who is undocumented in them, so somebody that in the future might be looking to become a permanent resident. And on top of that, you actually heard the director acknowledge that in the past, in the 90s, when there was an expansion of public charge under welfare reform and immigration reform, and people didn't quite know sort of if it applied to them or didn't. They were unilaterally withdrawing at massive rates from benefits, and we know that from history, and he acknowledged that to be true. And even though they were, it didn't affect them, or there was no immediate harm to them or their family members or household members in receiving benefits, they were choosing to withdraw, that chilling effect, right? But the solution that we heard from the director was that people should really look at those 455 pages to know whether or not they will be impacted by this public charge rule. So from a city perspective, this is deeply troubling and problematic, not just for people who are directly impacted, who at this time might be going through the process of adjusting their status, but for myriad other reasons. You're essentially saying that because you maybe received one of these benefits, or because you've lower levels of education or disability of some kind or what have you, that maybe the person that you love shouldn't be able to become a citizen. You're essentially saying, because I'm an undocumented mother, my child is a U.S. citizen, and they might be accessing some benefit, I might not know, right, that access of that benefit might not impact my ability to become a resident in the future, or maybe my other child's ability, therefore choosing to unilaterally withdraw my child from access of the benefit they're perfectly entitled to. That's the other part of this. Benefits people are actually entitled to receive are what we're penalizing. And so this is really troubling on a human level. It's very troubling from a public safety and health level. You want people to access benefits like medical care and housing where they're eligible for them. You absolutely don't want to see a massive chilling effect of people choosing to withdraw unilaterally from benefits or having their children withdraw from benefits. And we know how deeply complicated immigration law is, and what they've created with this proposal is an extremely complicated, unclear how it will get applied analysis, and therefore in a system where people are not entitled to immigration counsel, making it that much more shocking that something that's this obtuse would be the policy decision that's made on what should go forward. I'll just sort of briefly end with saying that, on top of sort of all of that, what we're essentially saying now is, if you're low or middle income, we don't want you, right, as a country or as a nation. And, there are notable exceptions. There are asylees are exempted, though we know from history that there were chilling effects on refugees and others in the 90s as well. There are other humanitarian reliefs that are exempted. But we're fundamentally saying that beyond that, we, one, don't care about the chilling effect. In fact, maybe we've done part of our job by scaring people so much for the last 2 years that they're already withdrawing. Two, we don't care how complicated it is, and if it's hard for you to understand it, withdraw, that's your choice. And three, we don't want you if you're poor, even though we know the trajectory of what immigration really looks like. When we know in New York City that $195 billion was what immigrants contributed to our city's economy last year. We know that small businesses are owned by 50% by immigrants. We know that immigrants are actually receiving benefits at the same rates as citizens, not more, not this sort of illusion of, oh my God, they're completely subsisting on our welfare system. We also know that immigrants, particularly second-generation immigrants, are actually contributing more to the economy than native-born Americans. So we have to kind of cut at the facts and tell an honest story about what this proposal actually means and the real impact it's going to have on families.
Great. So, Jonathan, those of us who didn't read your New Yorker piece over the weekend, you did reporting on what you see the impact to be. So if you could quickly summarize that.
Yeah, and thank you for doing the heavy lifting on that. I'll follow up with a vignette. And then, So I, just to put it simply, I spent a few days last week at the offices, at the Queens offices of an organization called Make the Road New York, which some of you may know, an organization that I've worked with a lot over the years, and an organization I particularly respect because of how much work they do to try to walk community members through the vagaries and complexities of various policies like this one, but also who do it in a way that I think really, and this is just a sort of a personal appraisal, who do it in a way that I think really allows people to make independent choices. So they're a community resource and they're advocates of a sort, but they're really trying to put information in front of people and let them make their own decision and sort of gently guide them and help disabuse them of any misapprehensions, et cetera. So I spent a few days in their office, just on the days following the announcement of the newly proposed regulation. And there's just one story that I can tell that I think would illustrate the point. I sat through what was essentially an information session that lasted 1 hour. The person who led it was a lawyer, extremely smart, extremely capable of presenting this information in a clear way. She had slides. People were asking questions in English and Spanish. Everything was fully transparent, entirely clear. I was taking notes. Everyone else was taking notes, for that matter. And you came away, given even the denseness of the policy itself, you came away with a few very clear, if provisional, kind of understandings. Namely, most of the people in the room were not directly affected by this policy. It would not affect them or their family members for specific reasons, but they would be unaffected. And for those in attendance who might in some way be affected down the line, they wouldn't be affected for a long time for technical reasons. So this policy, as Director Chishti mentioned this morning, it has not, I don't know if now it has, but as of this weekend, it was not published in the Federal Register. As a result, the clock didn't technically start ticking, but as soon as it's published, there will be a 60-day comment period. After that, there will be another 2 months, as I understand it, before any agreed-upon regulation goes into effect. For the most part, in some cases, there are, as I understand it, the effects will not be retroactive for some of the people who were in attendance. All of which is to say that for those who wouldn't be directly affected by this policy, fine. For those who might be directly affected by this policy, there was still time, and these are people who desperately need some of these benefits. So I sat through this information session. I heard the same information as obviously everyone else in attendance, and I spoke with a few people afterwards and asked them, okay, you have recently stopped your use of, in most cases, they were food stamps, and they were food stamps for U.S. citizen children of parents who were either here legally and pursuing a green card, or who are here illegally. But in any case, citizen children. All of them had stopped their reliance on these benefits well before even this policy was announced, because there was a cumulative effect to all of the prior announcements of drafts of this policy. So there was an unpublished and unexecuted executive order, I guess you could say, from January of 2017. People aren't like parsing the language of that, but it's reported on, and there's talk about it. There's talk about it on TV, there's talk about it in people's communities. Then again, in March of 2018, there is a much more aggressive proposed regulation that is leaked, that does not end up being the thing that came out the last weekend, but nevertheless has an impact on how people begin to think about this. And then, of course, there's the fact that Donald Trump is president, and his administration has a very specific rhetorical posture and a very specific enforcement agenda. And that already is driving people into the shadows. So there's this cumulative effect, and people have already gone off of benefits they need. And even after getting the information, I guess this is a very roundabout way of making this point, and then I'll be done. Even when people get the information, I mean, I witnessed them getting the information, they were not convinced that it was worth the risk. Even then. It was extremely striking, just on a human level, to basically see the argument laid out in very clear terms. And so it was striking this morning to hear Director Chishti's response to a well-taken question about chilling effects. You know, to say, well, just consult the 450-page document. Even with people interpreting that document for them, there were still questions. So that's the sort of vignette that I wanted to offer.
Great. So, Ur, I'm going to designate you to respond to the rule of law. So, since you spent time at two branches of the government enforcing the rule of law, so what is wrong with Jim's argument about the importance of rule of law? And while you address it, those of you who are inclined to ask questions, please go. This is the time to line up at the mics while Ur is taking on this heroic task.
That's pretty funny. So, the rule of law. It has been something that has been discussed for a while now. It's not a new thing that has come up since this administration, so it's been something that's been discussed since I can remember. So it's become an overused term. It's lost its meaning. The rule of law is used to justify a lot of things that are actually contrary to the rule of law. So let's take, for example, we could go back to the denaturalization. The rule of law is not a blind application, rote computer type of application of the law where you see something and you simply prosecute. Prosecutors sit down, they think, is this case one we want to bring? Is this a case that has certain equities? The Supreme Court said in one of these cases from 1943, again, 1961, I mean, it's just repeated, they said something to the effect, this does not mean that once granted to an alien, citizenship cannot be revoked or canceled on legal grounds under appropriate proof. They acknowledge that. But such a right, once conferred, should not be taken away without the clearest sort of justification and proof. Especially is this so when the attack is made long after the time when the certificate of citizenship was granted, and the citizen has meanwhile met his obligations and has committed no act of lawlessness, since, of course, that original act. So that, to me, encapsulates for naturalization what the rule of law is. It's not, otherwise we wouldn't need all of these lawyers at the Department of Justice or at DHS, for that matter, to try to figure out, should we bring this case, should we not? You would just bring all of them. But that's not the way it works. We're humans. There are human beings who have been naturalized, or human beings enforcing the law. And it has to be done with an understanding of the facts in each case. Another example, zero tolerance. Again, a bit of a blind application of the law. What was the result? A nonsensical humanitarian crisis. I think it was described rather well. And the rule of law cannot mean that you do it without regard to anything. And that's what it felt like. The description you provided, Jonathan, today, and I think we all went through it, you're sitting there thinking, how could the law be this way, that we're doing this to kids? So it cannot be that. And let's go to another example, which to me is the starkest at the moment. The immigration courts. A lot of us are following that. We had an attorney general who welcomed 44 new immigration judges and said to them in a very clear way, I'm here, essentially, I'm your boss, and these are the rules. Congress told me you have to listen to what I'm saying. And I don't have his exact quote. I can't believe I didn't bring it with me. But there was a very clear, oh, here we go. I thought it really worried me if I were sitting in that room. Immigration judges shall conduct designated proceedings subject to such supervision and shall perform such duties as the Attorney General shall prescribe. That comes from the INA. That's true. But think about this. These are new judges sitting before you. You're the Attorney General. Technically, yes, you are the boss. That is true. But this is an immigration court. For many, many years, we've set up an immigration court system that has very clearly moved the immigration court system not from controlled by the Attorney General and his policy points of view, political policy, whatever you want to call them, but really trying to seek an independence, these independent case-by-case decisions according to the law by these independent judges. They are not fully independent, but there was a time when they were not considered judges. There was a deliberate effort in the regulation to say they are now called immigration judges. Secondly, to give them black robes. So there's a sense, and those are just the clothing they wear, the names they're given, but there was a reason for that. And the rest of the regulations talk about a judge making a decision on their own, not being influenced, individual cases, being influenced by the Attorney General. Certainly the Attorney General has the certification power and has used it quite a bit recently. But separately, to welcome immigration judges in the way he did, I think is rather frightening. The other things that we've seen quite a bit of is limiting the tools that, as you all know, limiting the tools that the judges need to kind of handle their dockets, which, as we know, are huge, and putting quotas on them. This is not normally what you see. We don't see courts out there with quotas. We don't see courts out there in which someone is telling them, you don't have the authority to do this or that. Let me remind you what the law is. You're not following it here. And let me measure you and your performance by the following metric systems that don't really apply in most other courts. We really need to have, if we want people to trust the system and to not use the resources and keep appealing, you need to have trust in the system, that there is an impartial judge before you. We all know that. But unfortunately, we're seeing what I think is contrary to the rule of law. We're eroding the sense that there should be faith in a system at the lower level outside of the federal judiciary that really should not be handling many of these cases. But as a lot of these independence, these tools of independence that we've applied to the immigration court for so long are being eroded, you're going to see an increase of appeals, and that should not be the case, but it will be, and I think that is a clear erosion of the rule of law in our immigration court system. So just another example, but I could provide a plethora of them and be able to explain the question of the rule of law with a bunch of other examples. But.
Great. So folks, don't be shy. If you want to ask a question, please go to the mic. But Jim, in fairness, I should ask you, did she change your mind? Wasn't
that good?
And actually, if she changed it, she made I think, the right legal argument. But add to this the reporting that we heard from this, that in the application of all these policies, we have seen grotesque suffering. Does grotesque suffering in the rule of law play anything to do with how rule of law is applied?
Certainly, application of the law always requires a recognition of the circumstance and the situation. Nobody doubts that, and nobody wants to see children suffer for no reason. And I would reject the suggestion that was made that this administration, I'm not part of the administration, but that this administration or anybody I could imagine in this administration desired to punish children or anybody else simply because of who they are. The bottom line is, however, and however difficult it might be to deal with, is that these people were acting contrary to our laws. There may be reasons for this. This happened over a long time for a variety of reasons, but and however unjust it might be to any particular one situation, they're acting contrary to the law. And these are things that we can't just ignore. The principle. We have large populations in this country that live in open defiance of the law. That has an effect. We have members of the bar now who are living or in this country illegally. I mean, to me, that is a contradiction that cannot be explained and must be dealt with. Otherwise, it leads to and encourages all these situations that are very difficult for all of us to deal with.
Okay, folks, any questions from the audience? Otherwise, I'm going to ask the questions of the panelists for the remaining 5 minutes we have. Any takers to the mic? Are you walking towards the exit or towards the mic?
We scared her away.
Thank you. Sorry for being tardy here. My name is Anna Gallagher. I'm an immigration lawyer with Maggio and Cater.
and I practice in DC, and I have a question for Mr. Peterson. I understand objectively you want to see the rule of law respected, but in reality, we have between 10 to 12 million people in the United States with deep ties. Congress has not passed reform. What do you do? I mean, practically, what do you do? Because I feel like we're talking up here an awful lot, and I understand why we are, but practically, what do you do? And then I have a second question. I don't know if you want me to ask the second question. I'll ask the section. And then I'll sit down and listen. In the second, my second question is about, we heard this morning, and I was at the border and actually heard reports of it as well from people in the detention center, that people who came to the border and asked to be let in, that wanted to seek asylum, were turned back 2 and 3 times. And these are people, seeking protection to which they have a right, and then they entered illegally. So my question is, what happens there with the rule of law? So the first one is the big picture, but can you give me a concrete answer? And the second is, what do we do with that?
Well, to deal with your second one first, surely we're not going to say that 2 wrongs are
No.
make a right. I mean, so the fact that there may have been a problem in the difficult situation of how to deal with asylum claims does not justify or excuse somebody who otherwise enters illegally. I hope we can all agree on that.
Well, I think
But,
the UN, I think, Mr. Peterson, I just think under the law, sir, for example, the UN guidelines, that people recognize, the United Nations recognized in passing the Refugee Convention, that people would use fraudulent documents to save their lives, that they would come into countries illegally to save their lives, and that was something that was recognized and considered and accepted, that people do those things. I'm not saying you should, but people do those things when they fear for their life. And I'm not talking about 2 wrongs make a right, but I heard several times just in a 5-day period from several people that when they approached the border seeking to apply for asylum in a legal route, they were rejected. That's concerning to me. And then the other is just very practical. What do we do with 11 million people?
My point, and I think we might be able to agree on this, is that this is a problem where we have these 11 million people, or maybe more. Part of the problem is we don't even know how many there are here illegally. The problem is this has been created over many decades. It's now created this very difficult, painful situation for many people that have these long-standing ties. Surely, though, the first thing we must do is recognize and appreciate that what the law is. The farther we get away from the law, it results in more and more of these difficult situations. Enforce the law or change it. That's all I'm saying. I mean, and it seems to me that certainly the lawyers and everybody, hopefully most other people, could agree with that. I'm trying to find common ground. I think there is common ground here.
So I will entertain the last question because we really have to close, but please go ahead.
Actually, it's 2 questions.
Try one. I know he's provoking a lot of people to come to the mic suddenly, but let's try with one.
My name is Treanor, and I'm a citizenship preparation instructor. And I have 2 questions. One is James, and the other one is for Jonathan. The United States is under human rights. So people coming to this country, as human beings, how can we turn our backs on children being separated at the border? How can we turn our backs on women or coming or fleeing abusive situations? Yes, they're going to break the law because that's the only way to get into the United States. And that's why they come here seeking asylum. If they were to come in through the law, there would be no sense for asylum, would there?
Okay, what's your question for Jonathan?
And my question is for Jonathan. We talked about the United States, children of United States citizenship, or eligible for programs, but the parents may not do so for fear of being a burden on the state. What do we tell our students, our clients, I have students in my class who their children are United States citizens, but they're afraid of seeking benefits. And I've been telling them not to because they don't want to become, be penalized as a public charge. But based on what you said, I think there is something different that we could be telling them, or am I correct?
Okay, Jim, you want to take a crack at why people are coming, if they could come legally?
Nobody denies that there are people around the world in need. And, obviously this country has been as welcoming as any country has ever been. This is a nation of immigrants. My wife is an immigrant from another country. I understand these things, okay? But the fundamental point also is true, that Americans should have a right as a nation under law to decide who to admit and when. If we want to have a more open immigration system, let's do it. Let's have our Congress agree to it. Let's not have a system where people are coming in illegally, spend decades in the shadows, resulting in a variety of situations where they're never safe, they don't get entitled to benefits, aren't able to do a variety of things. That is the problem. And again, from my perspective, it's not that complicated. If we respect the rule of law and enforce the law, we'll be fine. If we don't like it, let's change it. But I hope we could all agree on that.
I think we could agree on that. Jonathan, I'm going to give you the last word. Answer the question that you're asked. And if you've had 1 minute since you've done this, Bilby, is there any common thread among the 4 policies that we discussed today that could describe what the motivation of this administration is?
Why don't, for the first question, why don't I defer to you on this? Because I actually think you would have a more sort of expert answer.
Sure. I'll start by saying I think the number one PSA right now is that there's no change in the rule, right? So this is not law yet, it has not gone into effect. It will not be retroactive according to the language. So it's super important for people to know that at this moment, there's no change and there will be no impact on the receipt of benefits should they be utilizing them. That's number one. The rule hasn't been published at the time that it's published, as you heard. It could take 60 days for a comment period so people can respond, and it's so important that everybody do that. Why will this have a negative impact? What will it look like? Why might personally for your students this be a bad rule change? At that point in time, we don't know when it will become a final rule. So it's so important for people to get good advice, from not a notario or a fraudulent provider, but from good legal providers in the community, connecting them to people that you know that they can trust. We're happy. We run a coalition through the city of New York called Cities for Action. We have connections in a lot of municipalities, over 175 across the country, and can help people connect to good lawyers and get good, solid advice. But most importantly right now, don't withdraw because there isn't going to be a negative impact on you now. The rule is not final and won't be retroactive. And then one quick add-on I would say is that you can talk about rule of law in abstract, right? What you see right now playing out, and Jonathan is going to talk about this in terms of the singular thread across all of these things, is, for example, in New York City alone, you have an unhinged immigration enforcement apparatus. You have an increase by 65% in arrests across the board. And amongst that, you have an increase in arrests of people who have zero criminal history by over 200%. You're not talking about an operation that has unlimited resources or an inability to prioritize or recognize that you put forward people who might be a threat, people who you have concerns about when you can't do unlimited arrests and enforcement. But that's not what we're seeing, and that is fundamentally the problem with the way things are playing out right now. It is not black and white, rule of law or not. That's not how it functions. Ultimately, and what we're seeing right now, is no logical discretion and prioritization on who should be targeted and who shouldn't.
Really rooting to be saved by the bell here, but
It's like you're an NPR and you're
yeah, ooh.
30
I
seconds.
thought it was bad when editors asked to have things boiled down. I guess insofar as there is a through line in all of these policies we've discussed, it seems to me a few quick things to note. One is the idea that everything immigration related these days seems to be subsumed by the enforcement agenda. And so any other government agency that has any interaction at all with immigrants or immigrant communities is somehow being brought under the umbrella of the administration's enforcement agenda, which has a lot of these decidedly chilling effects in the community for understandable reasons. And the justification has often been this sort of very zero-sum approach, that if we don't go all the way toward kind of opening up any possible enforcement avenue, then we're somehow grossly falling short of respecting the rule of law or of sort of being true to our political promises. And the idea of such a zero-sum approach across such a broad array of complex policies, I think, is particularly distressing, and I think we'll obviously continue to see evidence of the ravages of it.
Great. Thank you, folks. Help me thank Jonathan Blitzer, Bitta Mostofi, Jaddou, and Jim Peterson.